see we have people coming in. Welcome. We will get started shortly. Welcome, welcome, everyone. We'll get started shortly. Okay. Welcome to Webinars for Busy Lawyers. My name is Laura. I'm with LCL, Lawyers Concerned for Lawyers, Massachusetts. We love to bring you different takeaways from educational topics. LCL, if you are not aware, is Massachusetts Lawyer Assistance Program. We have a lot of free confidential services for lawyers, judges, and law students in Massachusetts. Part of that is our Webinar for Busy Lawyer series and programming, where we try to bring you in guest speakers on a range of topics of things that you were wondering about. Today, we are so delighted to have Judge Julie Field and Attorney Heidi Webb with us, and they are going to be talking about dealing with challenging opposing counsel, an issue for so many of you. And so they're going to teach us some simple tools to deal with it today. To let you know, we will have the presentation first and then questions and answers afterwards. As you go along, please put your Q&A in the Q&A section, and then we will address those afterwards. And to give you a brief background on these wonderful ladies before I turn it over, Judge Julie Kuntz-Field, she is retired from the trial court bench in the 8th Judicial District for Colorado after almost 11 years. She co-founded the Consilium Institute. She is widely recognized nationally for her leadership and trainings on issues related to domestic relations, domestic violence, mental health, mediation, trial practice, judicial and community education. And Attorney Heidi Webb is the creator of innovative Consilium process. She works with clients, attorneys, and judges and other allied professionals to navigate a better way through divorce. So Julie and Heidi, I will turn it over to you. Again, as folks have questions, please put them in the Q&A and we'll get that after the presentation. Thank you so much.
All right, thank you. And Laura, thank you so much for having us, and especially for having someone like myself who's an out-of-stater or an out-of-commonwealther here in Colorado. I did actually practice in the Boston area many, many years ago, working with the firm of Nutter, then known as Nutter, McLennan and Fish. So it really is a pleasure to be back here. I wanted to just start briefly, though, to talk about how complex this issue is. And we can tell based on the number of people who are here today how impactful this is on your life, on your practice. And I really appreciate that it is the Lawyers Concerned for Lawyers group that is bringing this to everyone, because it is, I think, part of the complex dynamic, and the most frustrating part it can be of the complex dynamic of being an attorney. You have to deal with yourself and what you are doing. You have to deal with your client, what your client wants. You have to deal with opposing counsel and with the opposing party or parties. And then the other factor that's in there in that complex dynamic is the court. We will be talking primarily about family law in the context of the Consilium process and the Consilium Institute, which Heidi created, and she'll tell us in a second about why she created that and kind of what the genesis of that was. But I also practiced in a number of different areas and had a mixed docket, criminal, civil, family, mental health, dependency and neglect, when I was on the bench. So we'll try and answer some of those questions as well in dealing with those complexities in not just family law cases, where I think the illustration of the complexities can be most profound, but also in other cases that you may face. Heidi, do you want to talk about who you are?
Sure.
Kind of why?
Talk about sure, and how I got here. And I think this image depicts something that's sort of jarring, and I wanted to talk about the image, obviously, which is why it's there. But before we hop into talking about opposing counsel, and the difficulties that can the relationships can pose for us. I want to talk to you about why I care about that and how that topic became of interest. It was about 11 o'clock one night. I was watching the news and on flashed an image much like this. And I learned in that moment that the son of a former client of mine had been killed in Iraq, and was obviously devastated to learn that news, called her, went to his funeral. And at his funeral, I learned that one of his high school teachers who eulogized him said the reason he joined the Marines, or one of them, was that he felt like he'd never had a family. And I sat in that pew and I thought, my God, how did I contribute to that? The time, the energy, the emotion, the expense of a litigious trial when he was a young child had clearly left this young man feeling less than whole. And I was at a point in my own life when I had taken some time off. I'd had my third child, and I was able to reflect on how I wanted to go back to practice, and also had another lens. I had done my master's in education and psychology before going to law school. And I thought, if I'm going back and I'm going back to practice, I'm going to do it differently. And I started asking myself a lot of questions about what about the practice and the dynamic between attorneys and the dynamic between attorneys and clients, and restructuring families felt broken to me, and developed a process, as Julie intimated, the Consilium process that addresses those issues. So what we'd like to do today is sort of talk to you about some of the takeaways and some of the things that we teach in that process, and that we hope will help you as you practice and as you deal with those difficult situations.
Oops, sorry, missed one.
Okay.
All right. So I think the first thing to recognize, and as I said at the beginning in the introduction, is that the context of the work that we do is hard, because we're dealing with lots and lots of different people, different personalities, different needs, different desires. And I think that's what makes our work at times very challenging, but also very interesting. So one of the things that we talk about in Consilium, and that I think is most critical when you're thinking about how do I deal with an opposing counsel that may be a challenging person, how do I deal with a court, how do I deal with my client and what they want, is really understanding the dynamics that are going on individually for each of those folks who are involved, but also collectively. So really starting from the beginning and focusing on the context of feelings, because that's really, we like to think that we operate mostly from our logical brain. My experience in history is that most people actually operate more from that sense of feeling, that sense of wanting to be safe, wanting to feel in control. So if you keep those two things in mind, that can be extraordinarily helpful as you're thinking about how do I deal with opposing counsel. So really focus on the context of the feelings. And one of the things that we talk about in the Consilium process, and one of the foundations of it, is internal family systems theory. And while it sounds like it deals with families only, it really doesn't. It deals with individuals and understanding their own perspective and the emotional drivers that they operate under. So in the work that we do, we use a very detailed intake process that helps family law attorneys understand both the individual dynamic of what's going on with their client and the collective dynamic of each person in the case. And that includes your opposing counsel. Because a lot of times when we are doing an intake, let's say in a family law case, we're focused on what does our client want, what do they need, how old are the kids, sort of those basic facts. And we don't always focus on really what's going on with the other party, or what's going on with the other party's attorney, which is one of the critical pieces that we want to try and focus on today. So by understanding each of those different players and what their motivations are, you can have a better outcome for your client and be in a better position to really deal with those challenging situations when they come up. So, really sussing out what it is the other parties or attorneys' most basic wants are, and how you can help get them there. One of the books that I'm going to recommend, I know there were a number of questions that came in preparation for this about negotiation. How can I be a better negotiator? And I strongly recommend the book Never Split the Difference by Chris Voss. And one of the things that he talks about is that there is a great deal of power in no. And people want the ability to say no. So if you are thinking about what that negotiation is going to look like or what the other party's interest is, if you can create a space where they can say no, you are actually going to maintain more power than you lose by giving them that opportunity. And really trying to deeply understand their perspective and what is motivating and driving them. So Heidi, anything you want to add on the context?
No, I mean, I guess, this is all, you'll see this sort of all come together as we talk about the various pieces, but I think understanding the context requires almost taking a 30,000-foot view of the case, looking down at it as if, yes, you are an advocate and yes, you are representing an individual, but also you are part of a larger system. And the system that's being created, you're contributing to, and you have power over. You have much more power over it when you understand sort of how that's playing out and who the players are and what the overall sort of dynamic is that's sort of being created and that you're contributing to.
Yeah, and I think that works also in any individual conversation that you may be having with the opposing attorney, particularly those challenging opposing attorneys. I think being able to mentally step outside of the situation as though you were watching from above can be extraordinarily powerful. So as though you were a third party watching the interaction, that will actually give you some insight and ability to be able to understand better what the dynamic is. So taking yourself out of that moment can be extraordinarily helpful. One of the tools that I used to do that, both in my personal professional relationships and particularly in the courtroom, was, and I highly recommend it for anyone who's willing, improv comedy is extraordinary because it gives you many, many skills, including being able to step out of the situation and look at it from above. So the day I was sworn in as a judge, I started an improv comedy class. Best thing I ever did, because it helped me learn to listen, it helped me learn to observe, and to really understand different people's motivations. So that's tip number one, to help understand the context.
So clarity. What does that mean in terms of getting clarity on a case? I think a lot of times when we're representing a client, they're coming to us for advice and we're in a mindset of giving advice, as opposed to really trying to understand first what it is that the client's looking to achieve. I mean, they're coming to you, of course, for your advice, but also they don't understand the landscape and the context of possibility. And getting clear on what their North Star is and what really matters to them is going to help you team with them and create a shared vision that allows you to act on their behalf and contextualize the case for them, and also to really understand what the goals of your client are and where they're aligned perhaps with, and they don't even recognize it, with opposing or perhaps their spouse, and oftentimes that's children. There are places that clearly parents are aligned, but they're at a point in their own lives where they're seeing so much red or feeling betrayed or angry, or there are so many other things that are clouding their vision that they're not able to see clearly the places where there's agreement. So helping gain clarity on where there is agreement and what the issues really are can help you be a better advocate, and also help you understand when opposing counsel is angry or not really having context or clarity, or really oftentimes what we find in the concilium process is that the opposing counsel doesn't have a clear vision of what their own client wants. So they're taking a position and being oppositional in an effort to win without understanding what the context is. And that creates a lot of sort of disharmony between an attorney and their own client often, and creates anger, and they often then act out and sort of are angry at opposing counsel because they're frustrated with the situation that they've sort of created, not intentionally even, but by lack of having really taken the time to create a vision and to have sort of a greater context for what they're doing. Do you want to add something to that, Julie?
Yeah, I think in terms of that clarity, I think really making sure that you, as Heidi said, that you have clarity about what your client's North Star is can help, because if you are maintaining along with your client the highest goal is, right, and understanding what it is that is their ultimate goal. Maybe it is to, in a divorce case, say to maintain the house, right? And recognizing that whatever the negotiation or conversation is, that is the highest goal, and keeping an eye on that. And maybe there are secondary goals that are built in there, but making sure that you are always going back to that. What is that North Star? What is your highest goal? Is it to keep the house? Is it to have a good relationship with your kids? Is it, to get a settlement in a personal injury case that can allow you to have live in assisted living if that's what you need? So whatever that goal is, and I know that we think about that as lawyers, we're always thinking about what is the goal, but sometimes I think we get caught up in what is the goal in the moment, instead of thinking what is the long-term goal and what needs to be done to achieve that long-term goal. So a key grounding question can be to ask your client, if this agreement were reached today that was not ideal, but you could live with it, what would it have to include? That can be a good foundational question to help get you and your client in particular back to the North Star. It can also be a good question to ask the other party and the other party's attorney. So really focusing on that North Star and making sure that you're not losing sight of it, even in the heat of the moment. Being calm is your superpower. It can be your superpower. And so the combination of being calm and being able to have that 30,000-foot view can be extraordinary. When I was a young lawyer, I was sent out into the hallway to negotiate with an opposing counsel on a family law case who was totally, she was a yeller, she was a screamer, she was, just like the most obnoxious attorney known in that region, in that large urban region. And I went out into the hall and she's screaming at me, screaming at me, screaming at me. And I just stood there, was very calm and and didn't respond. And she said at the end, she said, you say I'm the one who's out of control, and you sit there with your calm little voice and tell me I'm the one who's out of control? Because I would say, okay, let's just talk about this. Let's just talk about it. And she's like screaming. And the absurdity of that really, I think, brought home to me as a young lawyer the power of calm and the power of silence. That can be an extraordinary power, and that you maintain the control then rather than ceding it to someone else. Heidi?
Yeah, I mean, I think that's a really disarming thing to do. and people don't expect it. When people yell at you, they're sort of asking for you to yell back at them. And when you withhold that and you don't react, they're confused. I mean, that's a confusing messaging. So I think the part of internal family systems work that Julie talked about earlier is really understand. It's hard to go into this in the short time we have, but I'll say that what it is a non-pathologizing psychological theory that acknowledges that people are comprised of parts, many parts. So there are parts of people that reflect their experience from childhood, that are based in pride, based in anger, based in shame, based in a lot of different things. But they cause us to react in certain ways in the moment. And the more we understand our own tendencies that way, the more we can respond in a way that's not reactive, but is thought out beforehand and allows you to sort of see what's going on and then think to yourself, okay, that this person must be angry, or they're trying to incite anger out of me. But since I won't let that happen, I can then reflect back that something like words like, there's a part of you that must be very angry, but I believe there must also be a part of you that really wants to resolve this conflict for your client. That's a disarming statement to somebody, because they can't deny that they want to resolve something for their client. I mean, that's their job, but they're obviously acting in an angry way. So that it's a dual language piece that gives you the power, because you've sort of called them on their behavior in a way that also gives them an out. So hopefully that's a useful tool, and we can talk a bit more about that as we move on.
Yeah,
Did you want to add to that?
one other thing I want to just note is that it can be hard to be calm in that moment. It can be very, very hard to take that 30,000-foot view to be the centered, calm, silent person when you feel like you're being attacked. One of the things that I learned was just a very simple breathing technique. Some people call it meditation. I just call it breathing. And it's extraordinarily powerful. So I don't know if folks are meditators, or if you're not and you're skeptical of meditation, just do some deep breathing. 3 or 4 or 5 deep breaths will help find that center and that calm. And it can be just extraordinarily powerful. So if you're finding that you don't have that centeredness, that calm, that superpower, that's one way to get it back quickly.
A little bit of magic. Curiosity, I think, is really underrated. It is incredibly important, and I think people are quick to move to advice and wanting to solve problems before they really get curious. And this works both in terms of your client, sort of the stated goals that they have when they walk into your office initially, versus the why behind the what. So when they're saying, I want to stay in my house, that's a statement. Why? You know, is it security? Is it the schools? Is it forever? Is it for 5 years? You know, what is it that really is driving that initial statement? Rather than just deciding that what that is my client needs to keep the house and that's the number one goal. Maybe your client needs to keep the house for 5 years, and, you know, refinancing causes certain problems that will make that really difficult. But with the knowledge that it's only 5 years, you can look at different kinds of possibilities for refinancing. I mean, there are many ways to sort of dig deeper and get curious about what you're first told from both opposing counsel, and from your own client. But I think it's really important to be curious and be in the moment enough to not need to get a solution immediately or advocate immediately, but to step back and ask those next questions that may seem like they're not getting to sort of the immediate resolution, that they're going to be a detour. But I think it's really the detours that sometimes give you the information or the nuance or the meat to really what allows you to reach a more powerful solution that has longer lasting impact and really more legs, particularly in family law solutions for families. Did you want to add to that, Julie?
No, I mean, I think that curiosity is your other superpower, asking people why. Where is that coming from? What does that mean to you? You don't want to say, why are you being such a-hole, right? But you want to find out what is underlying that perception. And I think it does go back to one of the things we talked about earlier, which is, making sure that you are keeping clear about what the North Star is for your client, because that will help you contextualize what you're hearing from the other person and also help you understand by asking those curious questions where they are coming from and really being able to um, respond to that in ways that you are using their interest in furthering your clients.
I also think that it's a question that people are often reluctant to ask, but it's also quite disarming when someone's very angry or yelling is, can you help me understand why you seem so angry? Which seems so basic, but it's a curiosity question. It's not accusatory, and you're not angry. You're just asking for help, but in a way that makes somebody stop and say, well, I'm not angry, or well, you sound angry to me, maybe it's your tone of voice, but it seems to me that you're angry, and I was just having a hard time understanding why. So, I think not being afraid to sort of go to that next question can really get you quite far. Um, or is there a reason that you feel like you need to yell to get your point across? Something that points out both what someone's doing and that it shouldn't really be necessary. Like that's not helpful. Um, so I think the other thing, that I guess I am particularly fond of pointing out to is that we have two roles as attorneys, to be a zealous advocate and to be wise counsel. So I think that it's a very fair question to say to opposing counsel, at the end of the day, I wonder um, if your zealous advocacy really aligns with what your client needs as wise counsel. That sort of puts someone back on their heels a little bit and says, what is my role here? What am I doing?
And asking that question with curiosity rather than sounding accusatory is extraordinarily powerful. I think one of the things that is key to all of this is connection, right? I think it's been challenging over the last few years since we're doing more meetings on Zoom and court on Zoom and interactions that are removed from that human contact element. I think it becomes a little bit more challenging to build those relationships. And one of the things that I noted, having a variety of cases in front of me as a judge, is that the case differences between the attorneys who had connections with each other versus those that didn't. So, for example, the criminal defense attorneys and the prosecutor in my small community, smallish community, knew each other and they knew what to expect and they knew who they were dealing with and they saw each other literally 3 times a week, right, in the courtroom. And so they had a very different dynamic than the people that came in from the big city in Denver and were in my courtroom just on one case. So building those connections, I think, through being on a board together, being in a group together. In Consilium, we have the Tapestry network organization that helps to build those connections is extraordinary. And having that connection or relationship outside the case And needing to continue that relationship helps to build trust and make it more difficult to be awful to each other, generally speaking. Every once in a while, you're going to find somebody who doesn't meet that general description. But most people, when they have a personal relationship with you outside of that one encounter or one case encounter, are going to be better and easier to deal with. So how do you build that if you don't already have it in place, right? If it's not the criminal defense attorneys and the prosecutors in the courtroom, think about what is something that you can use to connect with the other attorney that's at a basic human level. Kids, trips, school connections, ask questions. That curiosity goes to tell me about your family. Tell me, oh, you're going out of town next week. Tell me where you're going. What are you doing? Um, all people, I contend, have some connection somewhere, right? It's the Kevin Bacon thing, 7 degrees, 6 degrees of Kevin Bacon, right? So figure out what it is and ask curious questions about who they are and what they value. This isn't a tactic. This is understanding and building a relationship that will benefit you and your clients on a human level. And find other attorneys that you can work with who can help you understand your opposing attorney. When I first came to my community, I started doing mediations here, didn't know any of the attorneys. This was many years ago. And so I would ask around, who were the good attorneys, and I would ask questions about who should I get to know and what information would be helpful for me to know about this particular attorney that many people found to be problematic. So by building those trusted resources in my community, it helped me to become a more reflective lawyer, which I think is one of the things that we owe ourselves and our clients, is to be reflective lawyers and think about, what am I doing now? How can I do it differently? And to really use the tools that are available to you to reflect on what you're doing, the choices that you're making, and what you're going to do differently, better next time. Or if something worked well, reflect on, wow, that worked really well. I guess it's because I was calm in that interaction, or I stepped back, or I used my improv comedy skills, or I listened carefully to what people were saying. So that's one of the things that I think is extraordinarily powerful and is missing very often in the work that we do. Heidi?
I think I think it's important. It's difficult and important to stay grounded in those moments. I think when you know that you're going to have a difficult conversation, taking that moment before you have it to write down on a yellow sticky note, be curious, be calm, be connected, to remind yourself to be present in this moment. A lot of people who are, the angry opposing counsel have alienated a lot of people, and they're not used to someone being interested in them or wanting to connect with them, because their alienating behaviors have put them in a position where that's not a typical interaction for them. So again, when you reach out in a way that's unexpected, that can sort of make their day in an unexpected way. And I think that that's a really powerful tool that you have that you may not be aware that you have. So I wouldn't underestimate that.
And the Tapestry, as I said, is Consilium Institute's networking organization. And the name, the Tapestry, I think says it all, is that we are weaving and building a tapestry of connection within Consilium. But I think that name and that lesson resonates with what we're talking about today, right? And that is to build those connections, to build that tapestry, to build those interactions one piece at a time, and to weave that together in a way that creates a whole. A little bit slightly off topic, but I saw that there were a number of questions that came in ahead of the webinar to asking about, how do I keep my cool when a opposing counsel and judges are not understanding what I'm trying to say, or how do I deal with that attorney who is lying in court or misrepresenting things. And again, I think some of these, speaking from the judge's perspective, I do believe that it can be extraordinarily helpful to use and maintain many of the techniques that we've been talking about, that calm. I was always, at least in my courtroom, more persuaded by the person who was calm, cool, and collected than the one that was pounding the table and tearing their hair out. And how to make sure that judges can see that you're the one not being difficult. I think that's part of it, being that calm, cool, collected person. Um, and to be clear and straightforward in your communication. So if someone is misrepresenting something in court, the simple answer is generally the best. Judge, that's really just not true. That's not true. If you look at transcript page blah, 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 you can see that is what my opposing counsel is saying is simply not true.
Mhm.
So, yeah, so dealing with challenging opposing counsel in court can be particularly challenging because you may think that the judge isn't seeing it. I would venture to say 9 out of 10 times the judge sees it, knows it, understands it, and probably has some insights into that opposing counsel that you may not, because they may see them more frequently than you do. All right. That's all we have with our prepared remarks. And if you want to know more about what we do, consiliuminstitute.com. But I want to be sure that we're answering any questions that you have. We still have some time. So Laura, are there any questions that we should be focusing on?
Yes, thank you so much, Julie and Heidi. We've had a lot of great questions come in. To recap, I just want to do a few takeaways since you gave us so much great information. You talked about context, understanding the party dynamics individually and collectively, clarity, focusing on what matters, what is the long-term goal, curiosity, asking with curiosity rather than accusation, and connection, trying to build trust and find others who can work with you, trusted resources in the community to build connections. You also mentioned about the North Star, staying calm, cool, and collected, and meditation. I will note too that LCL, one of all services we offer is we have mindfulness for busy lawyers. So if you're interested in learning more about being calm, that is something that our colleague, Dr. Tracy, does. As for questions, we have a lot of great questions coming in. The main theme is about bullies. So we have questions, for example, this person practices in a very small court. They meet the same attorneys over and over. Is there a way that they can build a concrete wall to shake it off because they are thinking about not returning to court, that the bullies are so constant and so bad that they're always dealing with them?
Well, I'll take a stab at this, and then Julie, maybe you want to chime in with your perspective. But I think that, bullying behavior causes our lizard brain to sort of like jump into fight, flight, or freeze. I mean, that's a human reaction to being bullied. It goes way back to in our brain development. So I think knowing that about yourself and understanding your own internal parts, like what's your tendency? Is it to yell back? Is it to run away? Is it to sort of literally be speechless? Like, what does that behavior do to you? And then sort of try to, knowing that, pre-think, and instead of being reactive in the moment, pre-think how you can address that in a way that is disarming, to the bully. So they're used to you fleeing when they scream, and your reaction will be something different than that because you've pre-thought it, and you're then able to have the language to say to them, something akin to, you seem, or part of you seems really disturbed by this. Can you explain to me why? That you're retaking control and you're not letting the bully sort of be the person who sort of runs the show. You're putting them back on their heels and saying, explain to me basically your inappropriate behavior. This isn't acceptable as a grown up. You sort of need a timeout. You're almost talking to a child at that point.
Yeah, I think it is sort of that timeout. It's like, I will talk to you when you're calm, right? It's like dealing with the sort of out of control teenager, right? I will talk with you when you're calm. I'll come back later, or you come back when you're calm, and then we can talk about this. So I think dealing with a bully, one of the key things is, or several key things are to be firm, to be clear, to stay calm, and to maintain your own integrity.
Yeah, your
Uh,
own boundaries.
yep, your own boundaries. I am speaking right now. I'm speaking. You'll have your turn later. I mean, to be just as clear as you can be, and that can be hard in the moment, right? But I think going back to what Heidi said is thinking about what is it in you that is triggered by that, and what is, because it's triggering me, what do I need to be working on to be able to not be triggered? And I also want to say, just from the form of the question, the statement of, I don't even want to go to court. I don't even want to practice law anymore in this community because of the bullying behavior, is just, first of all, sad and outrageous. And I don't know what the tolerance of the bench is in that community for that kind of behavior. One of the things that I did in my courtroom was I had the rules of civility on counsel table. Because we have a principle in Colorado, that counsel will treat each other with respect, blah, blah, blah. And so I had that on counsel table. And if someone was acting out, or if I thought they were acting out in the hallway when they were talking with the opposing party, I would have them read it and tell me how they were going to behave differently going forward.
Thank you,
Yeah, I think
Julie.
sorry, I was just going to add one thing to the yelling and bullying, and I'm really sorry you're having that experience. It's, lawyer mental health is a piece of all of this too, in a really big way, and we don't have enough time to go into that right now. But I think that saying to someone who's yelling, there's a part of you that must be angry, or there's a part of you that wants to be heard, and there's a part of me that wants to be heard too, is sort of tit for tat and doesn't really work very well. But if instead you're saying there's a part of you that sounds like you really want to be heard, but there's got to be a part of you that wants to listen as well, is another way to say, you're not doing it all right now. You're not succeeding. So, without sort of putting yourself in the mix and without saying, I want to get a word in too, but just saying, do you have the ability to listen? Is that possible for you without saying it quite that way?
Good. Thank you.
And,
I
can
want to,
I just add one thing? Sorry, Laura. One thing I would add is to sort of preload those statements in your head and practice them in the mirror if you need to before you go into court, so that you are ready, so that you're not caught off guard in the moment, so that you know what your reaction is going to be when you're dealing with, oh my gosh, it's that same attorney that I always deal with who's always attack, 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 so that you have those pre-programmed into your brain.
Yeah, I think there's a learning curve. And I think initially none of this feels natural. And I think that that's hard. And to practice like in the moment, like Julie's saying, is really, really hard. So the more you can do it and make yourself feel like it is your authentic self that's presenting in that moment is a little bit of a challenge. But I think the first time you succeeded it is your best, incentive to say like, yes, I did it. And now I can do it. Then it becomes much more natural and it doesn't become so hard.
Thank you both. Our next theme, we have a handful of questions and comments on this, is regarding accountability. There are a number of statements of saying that judges are not calling out bullying behavior. They're asking if they should report people to the Board of Bar Overseers, who is our regulators in Massachusetts. They're finding that the court system is broken, and they find that reasonable attorneys stop litigating and they become mediators or leave the practice. Um, Julia, I'll turn this question to you. What can judges do? You mentioned before about the rules of civility. What else can they do to try to stop bullying behavior in the courtroom?
Yeah, I think the question really is twofold, the way that I'm hearing it. One is what can judges do in their courtroom to stop that bullying behavior, and that's an individual judge responsibility. And in my view, that was always one of the key pieces in my courtroom, is because people are entitled to due process. And due process means having the opportunity to be heard. And if you've got somebody who's bullying in the courtroom, then the other party is not getting due process. So I felt very strongly that I needed to provide due process in my courtroom. So on an individual basis, I think finding those judges who have that similar philosophy of I want people to be seen, heard, and understood in my courtroom, and giving them the opportunity to do that, whether it's posting the information on the council table, or orienting people to the courtroom. I did that early on in my career when I was a new judge, orienting people to what my expectations were in the courtroom, particularly for those lawyers that I saw over and over again, the public defenders and the district attorneys. But the other piece that I'm hearing there is that as a system, there's a sense that there isn't a um, expectation of that kind of excellence and professionalism in every courtroom from the top. And that can be a very challenging issue to deal with. In Colorado, I know the way that we are dealing with it is, in fact, in a couple of days, I'm going to a full day bench bar conference where we're having a dialogue between the lawyers and the judges in family law cases about what do the lawyers see and what do they need and what are their frustrations, and from the judge's perspective, what do we see, what do we need, what's our perspective. So having that opportunity for dialogue and
Mhm.
developing um, techniques within the system overall to deal with that is one thing that I know we're doing here. I don't know if that could be replicated in Massachusetts, but certainly it's this is our second benchmark conference in 4 years, and it has helped enormously in that context. So having that dialogue and um, not feeling othered, that the court is someone other than human people trying to do their jobs well.
Very good. Our next theme is trying to deal with bullying when you are a new attorney or when you are green to some of this. Thoughts to add on specifically for new folks.
I'm trying to think of particular, it's hard to get your footing. And I think, it's mentorship and having people sort of have your back and having sort of the confidence and building your own confidence is part of the learning curve, no matter what we're doing in life. And I know we've talked a little bit about the tapestry and about the Consilium Institute. You know, Consilium actually means Council of Wise Advisors. And the community that we've built is one of attorneys, mental health practitioners, and financial professionals. And we provide mentorship and the support within that community. I think that's one place to get it. I think knowing if you're have peers in your firm or colleagues or mentors in the firm that you're at is great. Many people don't, or they feel like that's not a place they can ask because they'll be seen as somehow deficient. And I think that's a really challenging place to find yourself. And I think one of the, you know, participating in other bar associations or places where there are people who are sort of growing with you and not competing with you is another place to sort of find community. And I think my dog just walked behind me if anybody saw that. She's the notorious RBG, known as RB.
Yeah, I guess one other thing I would add to that is asking the questions, doing that self-reflective lawyering piece, right? When I was a law professor, I would teach my clinical students to be self-reflective lawyers, and we had techniques and things that we did to help them reflect on what they did well, what they could have done differently not just in each case, but in each interaction. And I think at having the confidence in yourself to be able to go to someone after a case is over, even if they were particularly challenging people to deal with in the case, to ask those questions. That goes back to that question of curiosity, to say, okay, so when we were talking about this, it really was challenging for me to work with you on that issue. Help me understand, especially as a new lawyer,
Yeah.
asking for help, even from people that have treated you badly, can be an enormously powerful tool, because then the next time they see you, they'll remember, oh, yeah, Heidi came and asked me questions about how to be a better lawyer. Not that you're necessarily using the I'm going to scream and pound on the table techniques that were used against you, but it's also, again, part of building that connection of, I know that you, even if you had a bad encounter with them, I know that you have things you can teach me,
Yeah.
and
So
to try and identify what those things are.
thank you. For our next theme, several people have asked about this. They either have their questions or comments about escalating response to bar discipline referrals. There are some that note that they have history with opposing counsel. It gets personal in a very nasty way. They say that sometimes they are not trying to negotiate. They're just being bullies, lie, yelling, and demeaning. Some folks have noted that they're bullying rather than understanding the case or that they are misrepresenting the law. Um, there are several people asking about should they escalate the response to a bar discipline referral. Julie, what do you think on that?
Yes, I think so. I think if it gets to that point, certainly, I think it feels like a bit of a nuclear option, but it nuclear options exist for a reason.
I also think that we're a community and that's an unacceptable part of the community. And I think it should be called out.
Mhm. Yeah, I mean, certainly, do some of the things that we've been talking about before you get to that point.
Sure.
But if the only way you are going to get someone's attention and hopefully, maybe not, probably not, behavior change is to make the bar complaint.
You know, sorry.
Yeah, no,
I
that's
mean, I
So we
think it's sort of maybe a mental health issue for the attorney. And I think you may be, these are complicated issues when someone's really unable to understand, take direction, learn from their own behavior. You've got to question that. And they sort of become a person of concern in the community is how I would label them, I guess. rather than just, someone to be reported, but like this is concerning behavior.
Um,
We
And
need to address it.
I'll just note too, we had a comment from someone saying that be careful not to file false charges. So we have several more questions. I will try to distill out for the main themes going forward. And if you could keep your answers brief, we'll try to get through as many of these as we can. One is dealing with if it is challenging, it could hurt your client. So opposing counsel who do not know the law or the area of law, they may be flat out wrong but not admit it. If you teach them, it could hurt your client. If you don't, they will double down on a position that is contrary to the law. What do you think on doing in a situation like that?
I guess I'm the, we talked about the North Star of what the client wants. At least in my mind, I'm the North Star of trying to do what is correct under the law and the facts of the case. And so, and speaking as a retired judge, that is always, I think, the highest and best calling of the work that we do is making sure that we're getting it right. So to say that, teaching them what the
Mm,
law
yeah,
is going to hurt your client, that shouldn't
yeah,
be the circumstance. But if you feel like there's a piece of the law that is missing and they're missing it too, I don't know. I guess for me, the North Star is still always
yeah.
trying to get it as right as you can under the law and the facts of the case.
Yeah, I guess I'd need clarification on the question of that teaching component.
Our next theme is about double standards. Some people say that they feel that prosecutors and defense counsel are treated differently. Some people say that they're dealing with bias, being a female or a person of color, a minority lawyer. What do you do if someone is feeling that they are having double standards for different people in the courtroom?
It's it's an ongoing problem, I think. I mean, and I don't have an answer that I can give folks in the next even 4 minutes, but I think one of the things, and again, going back to Colorado and my experience in Colorado, is that's an issue that I know the court itself is trying to deal with in terms of, education and observation. At a point in my courtroom, I had people in my courtroom observing, and not just my courtroom, but all courtrooms observing. And one of the things that they were looking for was that. So I think calling it out in that way, not in an individual way, but if there's a way to create systems to be able to identify that that's going on and to address to the extent necessary and appropriate particular judges who are um, uh, not doing what they should be doing. I think that it needs, unfortunately, it needs to be a systemic response.
Right.
And
I also,
yeah, go ahead.
yeah, no, I was just going to say, I also think that, if you are feeling, as a woman, as a person of color, that you're being mistreated or treated unfairly in the system, I think it's important, back to the point of connections, to build connections with community members, people who are allies and people who are, in the same position, so that you're able to sort of see this as a systemic problem, not as a personal problem. Because I think you have more power when you can approach something together and have support that way.
Yeah, and the also the going back to the original part of that question and the feeling that defense attorneys are treated differently than DAs. I think again that is a systemic problem, and I think that at least in our um, court here in Colorado, that comes from the fact that we have a lot more DAs on the bench than we do
Mm.
offenders. And so I think that is part of the problem. So, if you feel there's a problem, become part of the solution. I do think that is a way to change the court from within, is to become a judge, to go through that process and become a judge. Um,
We'll have
and
one,
and to encourage people that are appropriate people for the bench who would not have those kind of biases.
we'll have one final question and then we'll wrap up. A person is wondering, does something like this work to say, I don't allow people to speak to me in that way. Please let me know when we can have a conversation without raised voices. What do you think?
Yes.
Yes, I think it's helpful. It's even more powerful if you can be it's a little bit of a defensive statement. I don't allow people to treat me that way, as opposed to saying to somebody, I might suggest saying instead something like, it seems like there's a part of you that feels a need to teach me, and there's a part of you that isn't very willing to learn, or something that sort of gives that parts theory back at somebody without sort of um drawing a line in the sand that sort of makes you the center of the interaction. Because I think when you're saying, I won't let you treat me that way, a bully's going to say, watch, I am going to treat you that way. Because that's where they think they have power. And what you really want to do is take that power away from them. And that's by pointing out their fallibility and their inadequacy, in a sense, or their foibles, their, the holes in what they're doing.
Excellent.
Yeah, I think there's
Julie,
a number of ways to be able to have that conversation with people. This is not productive. Call me when you're calm.
Yeah. Yeah. Yeah.
Julie, Heidi, I want to thank you so much for being with us. This is a very important topic. You covered a lot in a short time. I want to thank our audience both for being here and for your great questions. We very much appreciate it. Our next webinar for busy lawyers will be on Thursday, February 20th at 12 p.m. That topic will be subscription billing, a modern key to client retention. In the days coming up, you will receive a recording with this. If you've registered, someone asked about the rules of civility. We'll see if we can find those and include that in the email. And again, I want to thank everyone so much. If you have questions that you want to talk about on an individual level with us, remember that Lawyers Concerned for Lawyers does have private consultations on both practice management and clinical sides such as mental health, well-being, and so forth. We are here for you. Thank you so much and have a wonderful afternoon, everyone.
Thank you all very much.
Thank you.